With that, Wilson, I'm ready to turn it over to you and looking forward to hearing about this topic today.
Well, Alistair, thank you, Veronica, and Dave, and also thanks for having me on your webinar series. And I'm looking forward to seeing everybody in my hometown of Atlanta in May. So this is one of the few conferences that I don't have to travel, but looking forward to seeing everybody. And I also appreciate you guys allowing us to kind of discuss this topic because we ran into it probably in the last 90 to 120 days. And I can tell you, it was such the ramifications of what these tidbits in people's contract created. I brought Samantha back for one day. She was on maternity leave. She was close to, she was, in my opinion, coasting, but I did bring her back in for this one day to help me with the webinar that we did for our clients. And I'm not a controversial kind of guy. I'm fairly a compliant guy. I was a little surprised at the pushback that I got from some of our clients. But, so in 30 years of doing this, I can tell you this webinar is probably the one that we had the biggest pushback from our clients. But I can tell you it's absolute gospel, and I'm going to share some stories with you and some alternatives that accomplish the same thing. And if all is okay, what I'm going to do is if I'm going to go ahead and I'm going to share my screen here. There we go. Yeah, can you hear me okay now? Perfect.
Yep.
And I'm assuming you, okay, sorry, whenever I need to take it, mutes automatically when I take over the screen. So I will fix that going forward. But one thing I want to talk to you about, we're going to go into several aspects that we like to see you have in the screen or in the contract. But this one particular thing, everybody has heard of usury. And they'll pretty much say, hey, credit cards get away with it, and they may, but I think there's probably rules that are cut out specifically for them. But usury is basically, it has its origins back in the loan sharking days, and it's basically a series of state laws, and what's true in one state isn't true in the other, and we're going to kind of go through some of those nuances. But literally, and I'm going to give you some examples. I'm going to kind of omit names and companies and all of that. But some of you guys have put some stuff in your contract that literally is felonies. It's not even misdemeanors. And we had a brush up with a couple of attorneys up in the Northeast with one of our clients' contracts that almost had some pretty big ramifications for the client. But what I understand the intent, and we're going to kind of go through some of the alternatives, but everybody wants to make sure that they get paid. So they look at it and say, okay, I want to make sure that I get paid on my contracts, my agreements. So I'm going to make it so punitive that they pay me first. I understand the logic. But the problem is if you start saying, okay, I'm going to charge, if you don't pay me, my $20,000 or $25,000 for this placement fee by, May 1st, then you now owe me $1 million. Everybody would look at that and say, oh my God, Wilson, that's crazy. And everybody would agree with that. But there's a lot of recruiters out there that have a 10% per month or even a 5% per month penalty late fee that's compounding. A 10% late fee on a $25,000 fee now means if they don't pay you for 7 months, they pretty much owe you double. So, people look at it and say, well, that makes sense, time value of money. Unfortunately, there's certain states that view that much, much, much differently. And so as we go through this, the only thing I'm going to suggest that everybody keep an open mind, and I'm kind of throwing this disclaimer out there because it was so controversial when we did it with our 3,500 recruiter client base. But you need to make a decision. Are you going to be a recruiter or are you going to be a loan shark? And I've worked with enough recruiters to know that you're going to make far more money being a recruiter than you ever will be being a loan shark. And, I've always viewed recruiters very similar to stockbrokers. The ones that are really good are professional. But, the stock market or the stockbrokers have an argument that, or a saying that bears and bulls make monies, but pigs get slaughtered. One of the clients that, like I said, we're going to hide their anonymity, and just so everybody knows, it had nothing to do with an NPA member. But was a younger recruiter. And with this being said, I actually I sleep very well knowing that the next generation's coming in, because I have a lot of millennials and a few Gen Zers coming in on our staff, and they work differently than we do, but they did an amazing job. And I'm a big fan of probably one of the few old guys that would say, hey, I'm a big fan of the next generation. So I'm not going to bash because I've seen this from older recruiters as well, but it seems to be a trend. And I don't know, my concern when this first came to fruition was, is there somebody out teaching a class on this? Because we never saw the 10% or the 15% late fee. But then, all of a sudden in a 60, 90, 120-day period, we started seeing quite a bit of that in contracts. Now, I'm going to go through the usury. I'm going to also go through some other things that you want to have from a collection standpoint in or out of your contract. But, we do have attorneys on staff, but we are not a law firm. I am a non-attorney. I'm giving you collection advice. I'm giving you business advice. Check with your own attorney in your own state, but and check with an attorney if you're in one of the states that doesn't have a usury aspect or usury laws. That's fine. But if you deal outside of that state, you want to check with attorneys in those specific states. And I'm going to share with you some code that you and your attorney can research. But what I want you to do is, kind of when you take a look at these usury laws, instead of putting 5 or 10 or 15% that's going to expose you, you can put in collection fees or attorney's fees, which pretty much accomplish the same thing. Now, with the issue that we ran into with the client that was up in the Northeast, he was, I believe, in California, and surprisingly, California has some very liberal usury laws, and liberal from the aspect of they're almost non-existent. So it wasn't a problem if he was dealing in the state of California. He wound up going to the Northeast, and a lot of people say, well, that's the Northeast, that's to be expected. And to some degree, most of the states do have some usury laws that are a little bit more aggressive, but the Midwest has them as well. But the issue that we ran into is the debtor had paid, we got involved, and the debtor had paid, I forget, it was like a $42,000 fee. We got involved, they paid that pretty quick. The client decided after we collected that he was going to send a demand letter to the debtor on basically this. It was 10% per month, and it was like another $47,000 because it had been about 8 months. Well, when the debtor contacted us, actually the debtor's attorney contacted us and said, your client sent us a demand, we've already paid that. And I said, well, you paid the principal. I have no idea what this other is because I haven't been involved. He says, well, I'm in the state of, and this was in the state of Massachusetts. He says he's charging upwards of about 130%. He says, I'm talking to the DA. I'm going to have a felony warrant issued for his arrest. I said, well, let's back up. You guys have already paid it. The principal, I'm sure it's a case of where left hand didn't know what the right hand was doing and things along those lines. And I went back to the client and I basically visited with him, and the client was combative. He says, look, he says, my contract says I'm owed these. he signed off on it and therefore I'm owed. And one thing I can say is your contract is your contract, but if it comes into conflict with a law, your contract will lose every single time. I can say, okay, I'm going to, years ago I was going to sell off my kids or whatever, and I sign off on a contract. It doesn't make it legal. So if you have a client that has signed off on it, even though it's on there, it doesn't make it legal. And what it ran into with this, we were able to actually resolve it, and we kind of reinserted ourselves to keep this client from having a felony warrant issue. And we'll kind of go through some of the case law here in just a second. But I didn't know, would they had extradited him from, California to Massachusetts over this usury? I have no idea. Felony, I know they treat differently than misdemeanors. But the last thing I would want if I were this recruiter is to have a felony warrant out for my arrest because of something as silly as these late fees. And so let's kind of drill down on the state of Massachusetts. And also, I have supplied everybody on this webinar. I have supplied the usury or panels, this PowerPoint to Veronica. She'll make sure you get a copy of it. But basically, in the state of Massachusetts, once you start getting above 20%, it becomes basically under the same laws of wiretapping, racketeering, and it is a class 4 felony. In the state of Illinois, it is a class 4 felony. In the state of Ohio, it is a felony, there again, 4th degree felony, in things along those lines. In the state of New Jersey, the maximum rate for corporations is 50%. In that example that our client had given, they were at 150 or 160%. So these aren't statutes that we think are there or not there. These are basically on the books. And one of our clients was almost, excuse me, I apologize on that. One of our clients had almost gotten arrested for it. Now, speaking of the state of New Jersey, and this is a couple of things that I do want to talk to you about with the other issues, is the state of New Jersey has just passed a law. Now, we have done some webinars in the past, I believe with Veronica, talking about just states that have laws on the books. But in the state of New Jersey, if you are a licensed recruiter, you have to be licensed to be able to deal in the state of New Jersey. And if you don't, you lose the right to use their court system, which basically means if somebody doesn't pay you, then unfortunately you're not able to use their legal system to get paid. They are now expanding into staffing. It has not hit contract. I realize most everybody on this is a recruiter, but if you have a temporary division or in the future, I think New Jersey is going to do it with contractors as well, as to where they're actually setting the bill rate. And so just be careful as far as dealing with the state of New Jersey on if you're not licensed, if you email wilson@aercollections.com and you send that over to us, I'll have the link sent over to you or my assistant where you can sign up for all of the licensing fee and things along those lines. Also, a couple of things that you want to have in your agreement is you want to remove these filler words. We're running into these issues where we're seeing clients put in their agreement if it's for our efforts or some disclaimer word. Basically, you only want to have in there from a collection standpoint, if you present a candidate and they hire them within 12 months, a fee is owed. And so that is all that you want to have in there. We have one right now that's going through litigation where literally they're basically saying, yes, they presented them, but we didn't ever reach out to them. And so somebody else presented them later. and therefore we don't feel that there's a fee owed, and by their own contract, it said by their efforts, we paid the other recruiter. As long as it says something along the lines of, if we present somebody, a fee is owed within 30 days, or within 12 months of that presentation, a fee is owed, it removes that disclaimer. Another thing that you want to have in there is if they're hired in any capacity or position, because if anybody's been a recruiter, and I know with NPA, a lot of them are seasoned recruiters, you've had this argument, well, we hired him as a contractor, we hired him as a consultant, we hired him as whatever position that you didn't present them for. You want to have in that agreement that it's for any position or any capacity. Another thing, and talking about signed contracts, and this is one that we sometimes have clients get mad at us, 87% of the time we run something through collections, we're going to be successful. That's the good news. The bad news is 1 out of 7, 1 out of 8, we're not going to collect. Disproportionately on the ones that we're not able to collect, and sometimes have to recommend suit, and then depending on the state, sometimes don't recommend suit, or those that don't have signed signatures on their agreement. A trend that we're seeing with some recruiters is they say, well, I have a signed agreement. When we go to look at it, they've signed their own agreement, but the client hasn't. And they say, well, I emailed it over and I signed it. Well, the best analogy that one of our staff attorneys ever gave me, and I'm going to kind of steal it from them, is if you're getting married tomorrow and you're wanting your spouse to sign a prenup, if you sign the prenup and you send it over to her and they don't sign it before you get married, you don't have an enforceable prenup, because they didn't agree to it. You may have informed them, but basically this argument of your actions by marrying me means that you agree to my prenup is the same argument of if we present a candidate and you hire them, then the act of taking that resume means that you're agreeing. Now, having that in there is a fallback position in the event that you don't get it signed, but it's not a replacement of a signature. Now, we collect probably 50% of the ones that come in here for recruiters, half of them don't have signatures. In some states, that's not a problem. In other states, it's a big problem. There again, going back to the state of Massachusetts, if you don't have a signed agreement, their Supreme Court has ruled, you don't have a deal. Now, we still sue, or have sued, with our litigating attorney up there in the state of Massachusetts. It's only a problem if the debtor brings it up as a defense. Half the time they do, half the time they don't. But my point being is that there's laws on the books that clearly say if you're a recruiter and you don't have a signed agreement, you don't have a deal. So kind of keep that in mind as you're going through your agreement. The one thing that I would put in there, and there again, check with your own local attorney, but on 1 to 1.5% a month, or whatever the maximum rate by the law, that kind of gives you some cover. Secondly, put in there that they agree to pay reasonable attorney's fees. They agree to pay collection costs. Those fees will help offset. Now, through the collection process where they voluntarily have to stroke that check, I can tell you less than 10% of the time, probably a lot closer to 5% of the time, we're actually going to be able to collect those collection fees without having to sue them. But where that does come into account is if we should have to sue them, then we're able to take that 35% attorney's fees and those hard costs and ask the courts to award them. It's still at the court's sole discretion, but you're much more likely to get attorney's fees than you are 150% interest rates. Now, the problem that you run into, and going back to the usury, and then I'll take some questions from Veronica and the group here, but the problem is if you have that in there, you say, well, if they bring it up, then I just won't enforce it. And this is why everybody hates attorneys, and this is why I tell all of the staff attorneys around here, this is why nobody likes you, because there's always shades of gray, and the debtors' attorneys that we're dealing with aren't trying to get you paid. They're trying to build a defense. But if you have a clause in the agreement that is so bad that it is illegal, it voids, in most cases, the entire agreement. Now, you can put in or have your attorney put in there that if any part is severed, then the remaining part remains in there, or what have you. And there again, fallback position. But by having the excessive late fees in there, you set it up to not only where you can get arrested, but B, where it can totally void your entire contract. And it can be very clear that somebody was owed. None of that is disputed, but if it's in there, they can bring it up. And it's gotten to the point where our attorneys went back to our own errors and omissions insurance and basically said, okay, if we run into these late fees that are in a contract, can we even handle them on a collection standpoint? And the errors and omissions insurance came back and has basically told us if it is excessive and it violates usury, you guys can't go near it. So it was a learning experience for us as well. So if you have that in there, are there other companies that can handle your collections? I'm sure there are, but if there's, they're going to run into the same problem. And if they don't understand the industry, and if you're in one of those states, all of a sudden you've got a felony warrant where you didn't have an attorney, and it was our staff attorney that was working with that debtor's attorney to kind of fuel things down to where our client didn't have an issue. But just kind of be careful on that. Now, Veronica, do you have any specific questions on what we've talked about here and as far as on the usury or the other issues of the contract? And my question to you, and because I don't know, does NPA provide contracts, best practices contracts, or is that something that you guys leave strictly to each individual office, which, I understand both sides of that equation.
Right. We don't provide contracts. Our members are all independent businesses and they run their businesses as they see fit generally. And the other thing, of course, as you've alluded to, is we're not lawyers, and, try to understand the legal ramifications globally would be tricky at best.
No, I agree with you. I agree with you.
I do have a question. Go ahead, Dave.
We do have a platform where our members share some of their agreements with one another, and they're not necessarily stamped with approved or this is a best practice, but there are people that do share their methodologies with others. So sometimes that's helpful to, that if they're done well. We don't always know that they're done well, but they do share with one another.
Well, sure. One thing that we could do, and there again, throwing out that disclaimer, even though it's prepared by an attorney, it's best practices. It's not meant as legal advice. But Veronica, if you'll send me an email, I'll give you a link, and as a free bonus to all of the NPA members, we'll give you access to our best practices agreement. They're going to be very vanilla, but they're going to be very direct. But there are certain issues, and I still say have it looked at by your attorney, especially if you're in industries where there's liability and things on those lines. Perfect example. We say arbitration and mediation clauses in the state, or if from a collection standpoint, or the absolute kiss of death. We could not get an attorney to handle, if we're not able to collect, get an account handled on a contingency if there's an arbitration or a mediation charge. But one of the aspects of if you're in a highly litigious industry, I probably would want to have a mediation clause if it were my business personally, to where they'd have to go through mediation, and kind of sets up those obstacles to kind of slow down suit or create an expense for them. But when they put it in there from a collection standpoint, they've created those same expenses and hurdles for themselves.
There is a question that came in that I think maybe is a good time for the topic you just brought up, which is basically, is there a best practice and contract wording that's acceptable in all 50 states?
I really don't think so, because each state is going to be different just based on their laws. I can tell you, having contracts signed is a perfect example. In probably 30 of the states, an email going back saying, hey, yeah, I agree to the terms is sufficient. In other states, it's not. So I'm not aware, or I certainly don't feel qualified, nor would any of our attorneys, to say, hey, this is good in all 50 states, because each state is different. A perfect example is if you're not licensed in the state of New Jersey and you use a contract, you possibly open yourself up to some issues there if you're practicing there. Surprisingly, the state of South Carolina has the same issue. If you have to be licensed as a recruiter in the state of South Carolina, or doing business in the state of South Carolina, and their bar is the one, their legal bar is the one that regulates it. So, my question would be is, why would attorneys be concerned with that? Or are they using it as ambulance chasing to whenever there's a complaint, it goes out, and then an attorney can pick it up and have the recruiter sued for operating and doing damages in the state of South Carolina, and some type of extortion play. And I say extortion a little bit tongue in cheek, but what one man's damages with an attorney is another man's extortion. So just be careful.
Wilson, we were talking before the session kicked off that it seems that slow paying clients are just becoming the norm, regardless of the terms that they've agreed to, whether they've bought off on your net 10 or your net 30. That they're not paying in net 10 or net 30, they're paying in 60 or 90 or 120. And so I think this, these fees become a way for people to try to avoid clients from moving the goalpost after the agreement is signed. Do you have, what's your take on that, and how do you avoid that?
Sure. Well, the biggest thing, and this is one thing that will speed up your cash flow quicker than anything else, and is, instead of having net 10 or net 30 days, put a specific date. If you place somebody today and your terms are net 10 days, then you'd say, hey, my invoice is due March 11th. And that will get you paid. That will cut down your typically your days in half for that invoice to come out, because whenever you put net 30, especially if it's a larger company, it's going to go to an accounts payable clerk. And is it net 30 from when they've received it, and it's had to go through the mail and go through 5 different hands to get to her? Well, she's going to post it when she receives it. If she has a date, then it's going to automatically elevate up into the system. But it also sets the time within your agreements, and most recruiters do have them, and I certainly recommend them from a collection standpoint, is if your client doesn't pay you within that 30-day period, it voids the guarantee. So if you have, they have to pay me by March 11th, then you've got a hard date when that 30 days starts. Another thing that I would recommend is create a 2 or a 3 letter, email, some type of notification system, that when you send out the invoice, when the if the invoice isn't paid by March 11th, have an email that automatically goes out maybe on the 14th or 15th and says, hey, our invoice was due March 11th. Our guarantee is valid as long as that's paid within 30 days. Please make sure that all payments are sent to us, and give them your information and what have you. If they don't respond or pay off of that within 7 days, send out another one, and then you send out your final one somewhere around. And I realize all industries are different, but that 45-day period is key, because what happens is when you run into one of your clients that's not paying you, are they not paying you just because they're having cash flow issues? Is it logistics because they're a massive company and they pay everybody at 90 days? Or are they test driving your candidate? And I can tell you, if they're unsure of your candidate and they don't pay you while that candidate is there, then the chances of them paying you if that candidate falls off before the end of the guarantee period is almost zero. Now, we can say, and assuming that your contract's written correctly, we can say you definitely still owe the bill, because of the guarantee was voided, and it's a replacement guarantee, not a money back guarantee. But psychologically, that client will almost always either want a heavy discount, or you have to sue them to get the full balance. So that's another reason why recruiters want to make sure that they get paid before that candidate falls off. Because if somebody is having cash flow issues and they're letting you string out and they're stringing you out, they may be doing the same thing to the candidate. And then all of a sudden you get a call from the candidate telling you it's a dumpster fire over there, and they're wanting you to place them somewhere else. So getting paid ensures that you avert some of those problems.
What kind of legal teeth do like venue statements have in contracts? So I know I sign contracts for hotels all the time. We're in Michigan, or the hotels we're working with are never in Michigan, and they'll always say, this contract is written, will be adjudicated according to the laws in Georgia or laws in California. As you mentioned, somebody in another state will say, well, you can't, that's not legal here.
Well, and let me kind of give you an overview, and I'm gonna talk from a collection standpoint, but I'm also going to go back to that example that I gave with arbitration and mediation. Arbitration and mediation is an absolute death sentence for a collection account trying to get it sued on a contingency basis. So I don't like mediation and arbitration clauses, but I do realize that there's business decisions there. When you run into jurisdictional clauses, the logic of it is, well, if they're in California, I'm sitting in Georgia, I want to be able to sue them in my own backyard and not have to fly out there because they owe me money. The problem with that is if they're in California and all of their assets are in California, or they're not using a national bank. If they're using a Wells Fargo, a Bank of America, then you've got some long arm statutes where you can probably garnish. But let's say they're using county bank of Orange County or whatever, and it's a specific California bank, and I'm using California as an example. You can insert any state. Problem is, I can sue them here, and then when they don't pay, I have a judgment. Well, now I have to domesticate that judgment in California, which basically means I have to sue them all over again. So now you have two sets of court costs, you have two attorneys, and if you're dealing with your local attorney and they say, well, heck, we'll just go ahead and sue them here, I would ask them, say, okay, if they don't pay, the fact that they're in California, is it going to be additional cost to have it sued in California or to enforce it? And they're going to give you some legal needs and then say, well, we'll have to send it to another attorney, and that, we'll get you a judgment here, but you'll have to deal with another attorney over there. That just doubled your cost. So from a jurisdictional standpoint, from a collection, if we have probably 80% of the accounts that we have jurisdictional clauses in them, we always tell the client there's always a risk that they could try to kick it out of their state. But our recommendation is, in this example, suing them in California, because it eliminates a step, 99% of the time. About once or twice a year, if that, we have somebody challenge it and we have to go to the original state, but we would have had a two-step process anyway. Another thing that you need to take out of the contract, and this is what Dave talked about, where people are sharing these contracts, people see things that make a lot of sense and to them until it's in practicality. One of them, we see the mediation clause. We have also seen where jurisdiction is exclusively in the state of New York or in Delaware. The problem is that was made by somebody that started out in New Jersey or New York or Delaware or whatever. If you're sitting in California, you place somebody in Texas, you now have to go to New York to sue them, but New York's going to kick it out because it didn't have anything to do with you, with the candidate, or with the company. So jurisdiction with sharing of these agreements, another thing that we see in these agreements, and I always cringe, is the prevailing party wins. Now that sounds great, But what they've done is they've built a time bomb in their own contract, because most of the time we're going to win. If you sue somebody, most of the time you're going to win. But what if, for whatever reason, you sue somebody and the judge rules against you because, you know, there was something that came up, maybe that you didn't know about, an email where he was talking with somebody there. All of a sudden, not only do you not get paid, but under prevailing party wins, you now have to pick up all of their attorney's fees. You can make that very one-sided and basically say, hey, if we don't get paid, you agree to cover all cost of collection and or attorney's fees. Covers the same thing, but you don't open it up to where if you lose, you're going to get stuck with their fees. And that the jurisdictional clause, when people are not even from that state, we've seen that. We've seen the arbitration, mediation, clauses in there. In from a collection standpoint, they make no sense. And there again, they just borrowed them. The other is that the prevailing party fees or something along those lines. Those are the big gotchas that before we send something out, we always sit down with the clients and say, here's the issue that you have. Also, we've had clients, and coming back to the example I gave earlier, where they say we've got a signed contract. When we look at the contract, it was signed by them. There wasn't even a spot for the debtor to sign. So it wasn't a contract, it was a sales letter that they sent out, and it was a one-way communication. So you just kind of need to be careful on those items.
Thanks for all that. It's a lot.
It is a lot.
Are there
one other thing?
Yeah.
One other thing, and this is something that one of my attorneys brought out to me, and I'm glad it just something that you said is talk about the laws of Georgia. And I'm going to use this as an example. You have to be careful how that's worded, because it would technically say the courts of, in my case, Cherokee County, located in, the state of Georgia, whatever. That there is a difference. And there again, I did this for 25 years until one of our attorneys said, oh, we got a problem. And it's like, well, just sue them there. It's like, no, that's not what it meant. Is when you say they're going to be governed by the state of Georgia, if it doesn't have a jurisdictional clause that says, in all litigation or the courts have jurisdiction, now if you're in New York, by theory, that New York attorney now has to apply Georgia law based on his interpretation. It doesn't necessarily mean that all of the litigation happens there. If it's talking about, Georgia law applies or whatever, it needs to be a specific court in a specific county, and get with your attorney on that, because those are the nuances that the attorneys can really help you with.
Sure. What are any new trends you're seeing in collections, and has your success ratio changed at all after the pandemic? Our business has exploded, and our business has exploded for a couple of reasons. I like to think, we've staffed up and we've grown and expanded, but also it's a tight labor market and it's a questionable economy. So high demand and poor cash flow and credit. So more folks are coming in for collections. Now, one thing that we haven't seen yet, and this is one thing, whenever there's a true recession, like what you saw in 2008 or in 2001 or whenever the last recession prior to that was, whenever things get really bad, the debtors and their attorneys just get very, very, very aggressive. It hasn't hit that level of aggression, and so we don't think that it's hit that level of bad yet. The economy still seems to be pretty good. We are having a lot of clients say, hey, we're kind of slowing down, but we're still doing business and things along those lines. But some of it also depends on what industry. Some industries are booming. The biggest trend that we're seeing is, and it's brought on by everybody sharing the agreement, and that is, you were seeing clients put in wording that just simply doesn't make sense into these accounts or into these contracts, because they are word sharing. So if you're not sure of what something means, and when I say not sure, I'd almost go to an attorney, or I would go to an attorney. I mean, go spend the $500,000, have them draw up the contract,
take our contract that we just mentioned that we'd share with you, have the attorney look at it. He's going to charge you $200 or $300 to make a few sentence changes, but it becomes specific for your issue because he's going to have more knowledge on that. But as far as on the trends, the debtors that we were seeing in the 90s are very similar to the debtors that we're seeing now. Collections are still at 87%. I mean, they may move a percentage point. Sometimes we hit 88, sometimes we hit 86. Litigation is still pretty good. The injection of the job boards out there, the referral job boards, are making some things a little more difficult because there's typically, in my opinion, the job boards have almost become like a master service agreement that we see over on the staffing, to where they're acting like the general contractor and they're bringing in the recruiters, almost as affiliates to fill these positions. That has some issues if they don't get paid from our client's perspective, because they can't go directly to the debtor that didn't pay them. They have to go through that job board or that referral service, which is in essence just a job board, because they're the ones that actually have the contract with the client.
Can you give us a little update on your success for collections as it pertains to backdoor hires?
Backdoor hires, and that's, we've got the other company, Backdoor Hires. We've located at it. I believe we're at $28 million in located funds globally over the last 5 or 6 years. And we probably have collected through collections, probably 30% were turned over to us for collections. Half of them wind up paying. And if you ever run into a backdoor hire, just reach out to the company that hired and basically congratulate them, send them an invoice, go through your regular process, and about half the time they're going to pay you without ever getting us involved. With backdoor hires, the debtors, are a little sneakier. We had one that where they're playing this shell game where they were presented to this LLC, but they sent them over to this LLC, and then they said, well, we don't know it because this is a company that hired them. You have to be careful on that, and if your contract's written properly, it really won't matter. But the collection rates on backdoor hires that we get in still hover around that 87%. The biggest delineation is if there's a signed contract or not. If there's a signed contract, we're going to probably get all of it or most of it. If it's not a signed contract, then sometimes it's going to be what I would refer to as settlement paper, where if they owe 25, the debtor originally offers $2,000, we get them up to $15,000, and at that point, my recommendation would be to take it, because if you sue them without an unsigned contract, it does come into a little bit of a towing cost if you're going to get paid.
All right.